Okay. So we're here to talk about the history of special education law and how it applies to today. And I'm Jessica Wood, doing this for Dr. Kathy Booth's class, SPED 5113. Okay, first slide. So first of all, we're going to talk about Public Law 94142. Congress passes the Education for All Handicapped Children Act in 1975 as Public Law 94142. And it authorizes the federal assistance to states to educate children with disabilities ages specifically 6 through 21. Congress later amends it to authorize federal aid to states to educate preschool children aged 3 through 6. And then later it would educate infants and toddlers birth to 3. Today we recognize that by Sooner Start here in Oklahoma, and we treat that planning with individual service plans. We call them IFSPs. The most recent amendments were in 1997 when Congress renames the law Individuals with Disability Act, or Public Law 105 through 107. We also call it IDEA. It was authorized again in 2004. Later it would become Public Law 108 through 446 and would broaden greatly the definition of special education. Okay, so more about the history of special education law. Various ethnic groups, genders, and individuals with disabilities have long fought for equal rights. The famous Brown versus Board of Education in 1954 is historically important for ending segregation in schools. And this allowed for blacks and whites to learn together all of a sudden alongside one another, supposedly in equal settings. The ruling Brown versus Board of Education overturns the previous Plessy versus Ferguson, which was from 1896, and that allowed for schools to operate in a separate but equal manner. And we know that they very much were not equal. So blacks were still very much discriminated against. That's why everyone was so glad when Brown versus Board of Education was passed, that it would open the door for a lot of other disadvantaged groups to come about and have their voices heard as well. Okay, so in this picture here you can see this is an iconic picture of a famous black woman talking to her daughter about the importance of the Brown versus Board of Education passing. And this picture is courtesy of New York World Telegram and Sun Collection in the Library of Congress. Okay, so was it separate but equal really? The Brown versus Board of Education ruling was indeed a landmark achievement for African Americans who had fought for their rights in Civil War and Reconstruction era. So after the decision in Brown, parents of children with disabilities began to bring on their own lawsuits against the school districts for excluding and segregating children with disabilities. Their argument was that these children were being discriminated against because of their disabilities. So the fight for individuals with disabilities would put up the years to come would become one of equal prowess and endurance. So the following will make mention and explain the significance of some landmark court cases for individuals with disabilities. Okay, we'll talk about January 1st, 1965, the Elementary and Secondary Education Act was passed, and this act was passed by President Johnson. It was so that the federal government could protect and provide students from disadvantaged backgrounds so that they would have equal access to public education. Within the act, there's a component that encourages states to create and improve education for students through a grant program. So it addresses the inequality and educational opportunity for underprivileged children, provides resources that ensure disadvantaged students have equal quality education. Okay. More on the Elementary and Secondary Act 1966, it becomes revised, and in this Congress establishes further grant program details to help establish the initiation, expansion, and improvement of programs and projects for the education specifically now of handicapped children. So this program would later be replaced by the 1970 Education of the Handicapped Act, which we'll talk about next. So this act, also called Public Law 91 through 230, like I said, was in 1970, and this is an effort to encourage states to develop more educational programs for individuals with disabilities. So, however, though, neither this act nor its predecessor establish specific mandates that would use the federal funds provided by those grants in a way that that would show significant improvement for children with disabilities. So we're making headway, but not quite there yet. We still have much room for improvement. Okay. 2 cases, however, would become major catalysts for change, and we'll talk about those now. The first of these famous cases, and they were both from the early 1970s, was the Pennsylvania Association for Retarded Children versus Commonwealth of Pennsylvania, known as the PARC. And the next one we'll talk about is Mills versus Board of Education of District of Columbia. Okay. So, specifically, the PARC dealt with the exclusion of children with mental retardation from public schools. In the subsequent settlement, it was agreed that educational placement decisions must include a process of parental involvement and a means to resolve dispute. So, today parental participation is ensured by several things, one of which is a mandatory notification of meeting to be attempted at the minimum of 2 times. One must be attempted written and one must be attempted personally. Additionally, communication must be provided in the parent's native language. The means to resolve disputes can be resolved in mediation, and if no resolution can be reached, parents have the right to file due process at that time. Okay. In Oklahoma, we have the Oklahoma Resolution Center, and here this is a place where we want to resolve issues before we reach the due process stage. So you contact them, and schools and parents both have this facility to reach out to if they need to for help prior to due process. Okay, talking about the Mills versus Board of Education of District of Columbia. This case involved the practice of suspending and expelling and excluding children with disabilities, okay, from that school district. The school district's primary defense in Mills was the high cost of educating children with disabilities. So the genesis of this case is found in the failure of the District of Columbia to provide publicly supported education and training to plaintiffs and exceptional children, members of their class, and the excluding, suspending, and expelling, reassigning, and transferring of exceptional children from regular public school classes without affording them due process of law. Okay. So continuing on that and how it relates to today, regarding the expulsion of children with special needs, no student today can be suspended without much legal procedure, without following much legal procedure. So after an incident involving suspension today, we have to have a manifestation determination to decide whether or not the act was related to their disability directly. We have to hold this in accordance to law. So if found to be a manifestation of the student's disability, then suspension cannot be enforced today. And this often leaves schools having to scratch their head and address all the factors related to the incident. And this may require behavior assessment and follow up with behavior intervention plan. These are all lengthy procedures that we have to follow in today's world according to all this previous litigation. Okay? So the judicial interpretations in case law. Case law is always changing and evolving, and IDEA will continue to evolve and be redefined by case law. Judges often look at legislative history and legislative intent when they analyze the meaning of a statute. There have been hundreds and hundreds of court cases in which can be referred back to. Their rulings and findings have helped shape the special ed today and will for many years. So introducing early state institutions. So we're going to get into some deep stuff here. In Oklahoma, prior to legislation mandating community-based involvement, individuals with severe disabilities had very few options. Oklahoma first established services for people with intellectual disabilities during the second legislature in 1909, with the creation of the Oklahoma Institution for the Feeble-Minded in the city of Enid. This would later become known as the Enid State Schools. So it's crazy to think that we actually had a state-sponsored school, I guess in a way, that was known as feeble-minded. A lot has changed since then. Okay. The second of Oklahoma's state institutions was known as Pauls Valley State Institution, and this one's established in 1907. So it was actually originated as a boys' school, and then it would later be converted into a state hospital for people with epilepsy. So in 1945, this would become a new facility for people with intellectual disabilities. Okay. So the third school, creation of HISM. In 1959, the 52nd legislature would recognize a need for overcrowding and the additional beds to serve a rapidly growing population of citizens with intellectual disabilities. They appropriated $1 million for the construction of this third institution on land that was donated by Mr. and Mrs. HISM. This was near Sand Springs, Oklahoma, in 1961. An additional $5 million was appropriated to complete the construction and fully equip the facility, which would become named the HISM Memorial Center. Okay, trouble for HISM. So we're going to get into what would become, what would start the litigation phase for HISM. Okay. Mary Ann Duncan, who was the mother of a patient at HISM, she was interviewed by the Tulsa World in February of 2019. She recounts stories of what she recalled from her daughter's experience there some 30 years ago. Duncan would pick her daughter up for weekend passes sometimes, and every time it was time to return to HISM, her daughter would scream and wail. She dreaded going there. One account, she even took the steering wheel and tried to veer her off the road, but she hated it. Of course, she was nonverbal, so she couldn't speak, or they couldn't really communicate about it in depth. Regardless, Mary Ann Duncan, like many others, which we'll talk about, had personal illness and financial restraints of her own, so she really had no other choice than to rely on state help. However, it didn't mean that she would rest easy with her daughter being there and the way that she would eventually be treated. She reached her tipping point after hearing about people having to lay in their own vomit and feces, and just the lack of overall care that had become so ghastly. So Duncan and a small group of parents met regularly to discuss what they could do to bring about change, and they would call themselves Homeward Bound. Okay, so the allegations brought forth by these parents of children at HISM Memorial Center would result in a class action lawsuit that led to the closing of the state-run institution, and it included negligence, abuse, injury, unnecessary physical and chemical restraint, and a lack of adequate medical care, clothing, and food and rehabilitative services. So here's a little bit of a closer look at some of those allegations. All 6 children eventually that would be named in the suit suffered multiple bites, scratches, cuts, among other injuries, and other signs of neglect included broken teeth, rashes, and fungal infections. One young girl had even reported a large infected abscess on her arm. Okay, this information specifically, by the way, comes from the interviewer named Mike Averill. He worked for Tulsa World, and he interviewed some other parents, including Mary Ann Duncan. Some of the other things that the parents said were that the living conditions they would describe, that their children had spent most of their days sitting idly in chairs or benches resembling those at a bus station, while being provided little to no services on how to function daily in life. So we haven't quite got there yet. Today, I think that we have so much in place to address how to function in life. We've come a long way from here. But more about that was sleeping areas were described as being large and partitioned off into small areas with multiple beds and very little privacy. Personal toys were said to be locked up and that the residents couldn't have them. Eating was done in large congregate settings where residents were served what one parent said unappetizing meals while wearing strange looking and oversized bibs to protect their ill-fitting clothes that were stained and in often cases way too large. Again, these are parent perceptions from their experiences of the time. Okay, so it's a little biased or one-sided. Moving on, we have some pictures of, well, what was the only pictures I could find of HISM, which are obviously not inhabited anymore. It looks like this is, I don't know, the back end of the building. The next slide shows what looks like a hallway. Has a little clock there. Maybe a water fountain used to be there. And then another back door entrance. It's pretty ran down, you can see. And on the next slide, you can see a bath area for one in one picture. And in the other picture, I thought this one stood out to me, whether the building was run down or not. This picture with these doorways looks like a prison cell or a prison block. The doors are obviously very heavy and they look like they maybe can only be opened from one side, but it doesn't look like a very friendly or inviting setting. So the next picture is a larger picture of maybe Hissam. That one kind of looks like maybe while it was operating, but you can see it's a very large facility. Okay, next slide. So this Marianne Duncan, she would later become contacted by the Public Interest Law Center out of Philadelphia, which was interested in representing the group in a lawsuit, okay? So the Law Center partnered with local attorney Lewis Bullock on May 2nd, 1985. And this lawsuit was filed alleging negligence, abuse, injury, and unnecessary physical and chemical restraint, and a lack of adequate medical care, clothing, food, and rehabilitative services. That was their claim, okay? The group, Marianne's group, Homeward Bound, was not supported fully at first. There was at least 30 documented families that joined in opposition against the suit. They didn't have anywhere else for their family members to go. I mean, they didn't buy it. They didn't agree with it. They didn't want anything to do with it. Not even Bullock, the group's attorney, was at first convinced that closing the institution entirely was necessary. However, later on, the Federal 10th Circuit Court of Appeals would affirm that judge's decision to close it in 1992. And Bullock said the closure of Hissam was a remarkable piece of judicial coverage.
Courage.
Next. So about those verdict and results, on July 24th, 1987, the famous judge of this case, Judge James Ellison, found for the plaintiffs and ordered the closure of Hissam. He gave the state 4 years to transition the residents into community-based care. So the ruling forced the state to create a new model of care and replace the old system. A community-based system would now be explored and attempted. The community-based system is one where people with disabilities live on their own in the community with various levels of assistance and work care. Okay, so about the people who had reasons to look the other way. Like Marianne Duncan, who was physically and financially unable to care for her disabled daughter, at least full-time anyway, this was the case for many, many others. So I think this is the reason why places like Hissam were allowed to continue on for so long. People were at a loss on what to do with their loved ones or family members with such severe disabilities. They had no other choice to rely on the state for support. And to openly bash the institution might mean that they would be right back to caring for the disabled child all alone, and that would mean disaster for them. So most did not speak out. Next. Community care today. In those years that they were closed as a residential facility and began transitioning their patients out into the community to follow legislation. Individuals with developmental disabilities, they just want the same thing as you and I. They want to work and live independently. So the overwhelming majority of former Hissam patients are now thriving in their community, and we have some cool stories on that. Thanks to the more than 100 community service providers, both profit and nonprofit, offering housing and employment programs, places like Hissam aren't really needed so much anymore. Okay, where there is hope. As people would learn of the cases where individuals with even the severest of disabilities could have success in their communities, people began to have faith that change was indeed needed all along. Lawmakers would feel good about passing legislation to fund public school and transition services for individuals with severe disabilities, and the more time went on and the more success stories happened. Okay, I have one neat story that I took an interview from. This is an interview from Nancy Anderson, who is a retired special education director for the 5-Star Interlocal Co-op. And I'm going to read to you what she stated about her experience with Hissam. She says HISA Memorial Center, one of Oklahoma's state institutions for the individuals with disabilities, built in 1964 due to overcrowding at one of the only other two Oklahoma state institutions. She names them as Enid and Pauls Valley, like we mentioned. However, in 1985, a small group of parents filed a class action lawsuit with attorney Lewis Bullock alleging negligence, abuse, all those things we said, chemical restraint, and lack of adequate medical care, clothing, food, and rehabilitative services. Ultimately, Judge James Ellison, as she remembers, be the one to help close that, and recounted that the 10th Federal Circuit Court of Appeals affirmed that decision in 1992. So as a result, the state was forced to create a community-based model of service to replace the institutionalized care patients had been receiving. Hundreds of those students went into specialized foster homes and public schools. Many of those students had a court-appointed guardian ad litem to represent them at their IEP meetings. She remembers that specifically in her time as a public school educator. So, during those years, she says that she was a special education assistant director at the time for Special Services Co-op, what it used to be known as, which covered 25 school districts in Oklahoma in 5 different counties. She says, we got 2 students with significant disabilities who had just come out of HISM. One student was a 19-year-old man, and he was 6'3" and weighed 225 pounds. She refers to him as Sam. Sam attended one of our co-op classrooms where the teacher was only 5'2" and probably weighed 125 pounds. At first it was quite challenging because he was nonverbal and was so big and strong. They had to teach him a few basic signs, which Angie used some pictures to communicate with him. After having 1 full year, he was able to somewhat communicate his wants and his needs to us. She said he was even able to attend the end of the school class trip to an amusement park and rode the Ferris wheel for the first time, with his teacher and an aide, of course. But he smiled the whole time, and she remembers that being a success story. Okay, so again, with numbers in Oklahoma for people waiting for care, we have more than 5,000 people throughout the state that are receiving community-based care paid for by state waivers. However, there's still 7,000 families on a waiting list to receive those same services. Okay, so we're almost here now. Institutions to individuals with disabilities thriving in their communities thanks to team planning. We've come a very long way from those days of institutions and then to the community-based services with the varying level assistances that are in place. So now there are many more guidelines now there are many more guidelines and mandated regulations that involve post-secondary transition and community-based planning. In Oklahoma, post-secondary transition begins being considered at the age of 16. Referrals are then made to the Oklahoma Department of Rehabilitative Services. We call them DRS for short here, so that individuals with disabilities can start to get the supports lined up according to their level of services that they need prior to graduation. So, again, continuing on, because law is always subject to different interpretations, attorneys and judges will often have interpreted sections of the law differently depending on their own personal perspectives. So in reading about special education law, it's important to know that interpretations and conclusions are likely to represent the opinions of the author. How a court interprets a law might be dictated by a single word, for example, may instead of shall. Vague and confusing words lead to litigation. So, one example, the term appropriate education has been litigated for more than 30 years. And in conclusion, as long as there is room for interpretation, special education law will always be evolving. And there are my references. You can see I had a long list of sites and people that I utilized. Thank you for listening. The end.